What is up, guys? It's Scott with Never Hedge, and today we are talking about the HCMC court documents. I went out and bought these for you guys so you don't have to. I'm going to try to link these downloadable version of this for you guys down in the description box so you can have them for free. But if you get value from this, please, it would really help the channel out if you could like this video and subscribe so you can be notified when I release more documents and do more stock updates for you. So let's get right into it with the introduction. I'm just going to do a brief overview. I'm not going to read every word of this 22-page document. That's why I'm linking it down in the description for you to download. We're just going to go through this quickly so you can. In their memorandum in support of their motion to dismiss under Fed R Civ P12 B6 Doc 31-1 opening brief, defendants explained that HCMC's complaint should be dismissed because it is premised on a wholly implausible allegation, i.e. combustion occurs in the IQOS devices specifically engineered to make combustion impossible. That is contradicted by the sole evidence plaintiff relies on to support it. For that reason, under well-settled Supreme Court 11th Federal Circuit law, the complaint is implausible on its face and should be dismissed. HCMC's opposition, Doc 36, does not meaningfully address any of. Instead, in a brief laden with misstatements of the law concerning the relevant pleading standards and mischaracterizations of the defendant's arguments, HCMC hides behind the procedural posture and non-existent claim construction dispute in attempt to convince the court to let this case get to discovery. The court should decline imposing that burden on parties. HCMC's deficient infringement theory requires the court to make unreasonable inferences and ignore unambiguous statements in the very evidence HCMC proffered. HCMC cannot prevail on the merits, and it should not be given the opportunity to use the judicial process as a leverage to extract a nuisance settlement. This case should end now. Part 2. HCMC's strained defense of its direct infringement claim only confirms its implausibility. HCMC does not and cannot contest the central point in the defendant's opening brief that MRTPA attached as Exhibit J's to plaintiff's complaint directly refutes the conclusory combustion allegations in the complaint by repeatedly and unambiguously stating that combustion does not and cannot occur in the accused IQOS device. See Doc 1-10, Exhibit J at 19. No combustion takes place in THS. Let's scroll down. This is gobbledygook. HCMC likewise does not and cannot contest that under controlling authority, the content of exhibits attached to a complaint supersedes the complaints or conclusory allegations for purposes of determining plausibility of HCMC's claim. See e.g. FTC vs. AbbVie Prods LLC. Derp. Instead, HCMC attempts to manufacture ambiguity on the law and the facts where none exists. This is pretty bold stuff from Philip Morris here. Exhibit A. HCMC relies on outdated pleading standards and bad law. While paying lip service to Twombly and Iqbal, which indisputably control HCMC, cites Auburn University versus IBM 864F Sup 2D 1222 for the proposition that to state a claim for patent infringement, a plaintiff need only include 1. An allegation of jurisdiction, 2. A statement that the plaintiff owns the patent, 3. A statement that the defendant has been infringing the patent by making, selling, and using the device embodying the patent. A statement that plaintiff has given the defendant notice of its infringement. And 5. A demand for an injunction and damage. Doc 36 at 9, citing Auburn. Not so. Auburn is bad law and applied the now abrogated pleading standard based Form 18 of the federal rules. 864 F Sup 2D 1225. The same is true in rebilling of lading, in which the Federal Circuit expressly differentiated from the Form 18 standard for pleading direct infringement in patent cases from Twombly and Iqbal in rebill lading, transmission, and processing cis-patent litigation 681 F 3D Form 18, however, has been gone for years in cases that rely on it for the proposition that the standard for pleading patent infringement is any different from the standards applicable to all civil litigation are bad law. All right, this is Part B. HCMC's unreasonable characterizations of the evidence establish that its claim is speculative. As explained in the defendant's operating brief, HCMC's infringement allegations hang by a single thread. The conclusory assertion that a statement in Exhibit J that nitrogen oxides and carbon monoxide, two important combustion markers, were reduced by over 97% in IQOS aerosol compared to cigarette smoke somehow shows that some combustion must be occurring. See Doc 146. In its opposition, HCMC characterizes this language from Exhibit J as admissions in documents defendants themselves submitted to the FDA, which at best show that the IQS tobacco heating system is 97% combustion-free, thereby admitting that some combustion occurs. Doc 36 at 2. This illogical leap that a 97% reduction in gases associated with combustion is tantamount to an admission that a minimal amount of combustion must be occurring is both central to HCMC's infringement theory as pled in the complaint and precisely the type of unreasonable inference that Twombly and Iqbal foreclose. Essential to HCMC's theory is demonstrably false assumption that there is no explanation other than combustion for the presence of trace amounts of nitrogen oxide and carbon monoxide. That seems pretty open and shut to me. I mean, if there's a 97% reduction in these gases, that means there's still combustion taking place. That seems pretty freaking open and shut. I mean, I could go on reading this forever. Let's read the red herring and then I'll wrap it up. And then you can peruse this at your leisure. We're scrolling down a little bit to part 3. HCMC's claim construction argument is a red herring. HCMC has failed to identify an actual claim construction dispute. An essential ingredient is missing from HCMC's repeated but vague assertions about an alleged claim construction dispute regarding the meaning of combustion. Any actual disagreement as to what combustion means? Nowhere in this brief does HCMC compose a construction for combustion or describe how its proposed construction would impact issues before the court. This omission is fatal to the opposition and dispenses with any notion that claim construction provides a basis to deny defendant's motion. See Tridia Corp v. Sauce Labs, Inc. It is no surprise that HCMC failed to propose any alternate construction. It cannot reasonably do so. As explained in defendant's opening brief, the 170 patent defines combustion reaction consistent with its plain meaning, heating to a temperature that causes ignition and burn. Accordingly, the court need only look to the four corners of the patent to understand the term. A separate claim construction process is unnecessary. Contrary to HCMC's assertion that defendants attempt to impermissibly rely on the FDA's scientific review to advance construction for the term combustion, that is unquestionably disputed. Defendants advance no construction from that document. There is no inconsistency between the use of the term combustion in the 170 patent and in Exhibit J and the FDA scientific review, in which the FDA validated Exhibit J's statements. HCMC mischaracterizes defendant's brief by claiming it relies principally on the FDA scientific review. In fact, defendant's brief focuses on Exhibit J, the only document that plaintiff attached to its complaint to support its conclusory allegation that combustion occurs. HCMC should not be allowed to run from the use of combustion in Exhibit J, given that HCMC not only attached it to the complaint, but relied on Exhibit J's reference to combustion markers to support its deficient allegation that IQOS meets the combustion limitations of the 170 patent. In any event, as explained in the opening brief, Exhibit J in the FDA scientific review use the term combustion in the same way that the 170 patent does to refer to ignition or burn. See Exhibit J at 23. The tobacco neither ignites nor burns. This heats tobacco to temperatures below the level of combustion. In sum, HCMC's claim construction dispute is nothing of the sort. There is no disagreement between the parties regarding the meaning of the term combustion and no discrepancy between the uses of the 170 patent and the document that confirm its baselessness of HCMC's infringement claim. So that's pretty much it, guys. So we will have to see what the judge decides regarding this motion to dismiss for PM. I'll put on my bird law hat here, and in this document they say that combustion is reduced by 97%. So, I mean, it kind of means that there's combustion there, and PM can go fuck off. Again, I'm going to link this document down below so you can just download it and spread it around to everyone on the internet. Thank you so much for watching this far. Sorry if this is a little bit longer than what I've been doing in the past, but this is important stuff, and I wanted you all to have it. Thanks so much for watching. I'll see you in the next one.